13. We'll now bring to order this meeting of the Texas Commission on Licensing and Regulation. Ms. Mahon, will you call roll, please?
Mike Mendez.
Present.
Tom Butler is absent today. Luann Morgan.
Here.
Fred Moses.
Here.
Catherine Rodwald. Here. Robbie Shaw.
Here.
Deborah Yurko is absent today.
We do have a quorum present. At this time, I would entertain a motion to excuse the absence of Commissioner Tom Butler and Commissioner Deborah Yurko.
So moved.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. We'll now go into executive session. Item D, to consult with our attorney concerning pending or contemplated litigation or settlement offers pursuant to Section 5510711 of the Government Code. Also to receive advice from General Counsel on legal matters authorized by 5510712 and under 5510774 of the Government Code, discussion of personnel matters.
go through Jay.
Like the best news you see is actually the Aggies out the lead of the rest of the the Sugar Bowl is out. I wish I would have bet money on it because I'm such a fool. That would have bet money to lose. Yeah.
Never in the history of college football, I think, you had starting the two starting quarterbacks, and the third one was a championship.
Well, he's done a remarkable job. I haven't watched him over the years long enough to really know. I just know what I've seen, and then of course he's got these records and streaks and stuff, and you're like, well, he had to be good to get to that. I still can't believe he was at Florida and kicking Ohio State's butt. Now he's at Ohio State kicking everybody. Yeah. Is it the Heights area up there by Cleveland? Or? Yeah, that's where Cardell is. Oh, Youngstown. I like politics. I told my dad, I was talking to him yesterday, he's like, I only like to watch Ohio State. I'm like, Dad, I like the forms to receive when I receive something.
Oh, okay, I haven't got any. Okay. Let me make an announcement about it, so. Try to figure out what to put on my junk. It is 8:38. The commissioners will now resume and come out of executive session. Move on to item E. There is no action on anything that's come out of executive session. So let's go on to item F, which is the approval of the minutes. Commissioners, I believe you've had the minutes before. You had a chance to review them.
So moved.
We have a motion to approve the minutes.
I'll second that, sir.
And second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to item G, the contested cases. Let's start off with number 1, Brian. I believe, Mr. Sharp, are you up? Go right ahead.
Bowman wanted to talk to you about.
Yeah, that's one of the cases that's come before us that I think there may be, I'm not sure if there's any commissioners that may have questions on this case, so that's why we wanted to bring you up. Commissioners, item number 1, Cody Lynn Bryan. If there's any questions for Mr. Sharp. If not, Mr. Bowman. You don't mind just kind of telling us about this?
This is Brad Bowman, General Counsel. Mr. Chairman, we'd noticed there are some kind of technical issues with this case, and our recommendation on it was to remand it back to the judge to correct them. It does not change the outcome in the case or the result in the case, but there are some inconsistencies that we noticed between the findings of fact and what appears to be the evidence in the record. And unfortunately, it's beyond, because it's delving into what the evidence shows versus what the findings of fact actually say. It's kind of beyond what we can fix at this stage of the game. So our recommendation is to remand that back to the judge to address those issues, and then the case would come back to you hopefully once those issues are corrected or addressed. And just for clarification, we're looking at findings of fact 5, 6, and 2.
Findings of facts 5, 6, and 2.
Yes.
Any questions, Commissioners?
I recommend we remand this back to the judge with looking at finding of fact 2, 5, and 6.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2, Bradford. And I failed to ask if there's anyone here for these cases. As your cases come up on the contested cases, just let me know. I think at this point in time, I don't have anything for anyone that's got a contested case.
I think Mr. Bradford signed in.
He may have, but he did not give me anything. So is there someone here for Mr. Bradford, representing Mr. Bradford? No. Go ahead.
Good morning, Commissioners, Mr. Chairman. My name is Ken Sharp. I'm with the Enforcement Division of the Department. And the case I have here today is concerning Mr. George Silas Bradford, Jr. He applied for an apprentice electrician license, and because of his criminal history, the administrative law judge recommends the denial of that license. In February 2009, the applicant was placed on community supervision for 6 months after pleading guilty to indecent exposure. 2 months later, in April 2009, the court revoked the community supervision, found him guilty, and sentenced him to 21 days in the Newton County Jail. In that case, the applicant had exposed himself on 3 different occasions to the same female cashier at a gas station in Newton. Now, at the hearing, the applicant began his testimony by admitting that all of the charges and the department's evidence were true, that there was no dispute about that. However, he later testified differently. The applicant said the indecent exposure charge happened because he accidentally ripped his pants. He said the other 2 exposure incidents must have been committed by somebody else in Newton who looks exactly like him. In April 2009, the applicant was convicted of evading arrest or detention. In that incident, sheriff's deputies had surrounded the applicant's house after receiving a report that he had taken an excessive amount of prescription medications, that he was drinking from a bottle of whiskey and holding a shotgun, and that he threatened to commit suicide. And the deputies tried to talk to him and tried to get him to come out of the house, and at one point the applicant indicated that he would come out, or that it was okay for the deputies to approach the house. But when they did approach, they heard the distinctive sound of a shotgun shell being racked into the chamber. The deputies were finally able to talk the applicant into putting the gun down and coming outside, but when he continued to resist their efforts to take him into custody, they had to resort to a taser gun to subdue him. Now, the applicant explained it somewhat differently. He said the sheriff came to his house and knocked on the door, but the applicant simply refused to answer. He didn't want to come out. He insisted that was the extent of the incident. Now, he later admitted that a shotgun was involved, but he downplayed that involvement by emphasizing that he never actually fired it. In January 2010, the applicant was convicted of the sale, distribution, or display of harmful material to a minor. The court sentenced him to 180 days in the Newton County Jail, but suspended the sentence for 2 years. He didn't make it 2 years. 5 months later, the court revoked the applicant's community supervision and sentenced him to 120 days in jail. This charge arose after the applicant's 15-year-old stepdaughter told her mother that the applicant had been showing her homemade pornographic videos of the applicant over the course of several years. At the hearing, the applicant explained this conviction by saying he should not have left his smartphone where his daughter could pick it up and look at the pictures that he had on it. In August 2010, the applicant was convicted of theft and sentenced to 30 days in jail. In December 2010, the applicant was convicted of resisting arrest reduced to disorderly conduct after he used physical force against a police officer who was trying to arrest him. In March 2011, the applicant was convicted of theft and sentenced to 3 days in jail. The applicant testified that for the most part, all of his criminal behavior resulted from the adverse influences of his wife. For example, she made him commit theft by having him shoplift merchandise when they would go to stores together. The ALJ found that 4 of the applicant's convictions were for crimes directly related to the occupation of electricians under the Commission's guidelines and recommended the denial of Mr. Bradford's license application. The Department recommends that you adopt the PFD as written. Thank you.
Any questions for Mr. Sharp?
Mr. Chairman, I don't have a question. I'm ready to make a motion.
Is there anyone here again? I'll reiterate, anyone here for Mr. Bradford? Mr. Shaw.
I make a motion to adopt the PFT as issued by the ALJ with the exception of noting the corrected date on finding of fact number 15 from 2015 to 2014.
Okay. We have a motion
Was it
So,
from
second.
2014 to
and a
2015?
second.
Did you say?
It's from 2014
it's
to
from
2015.
2014 to 2015, right?
Right.
That shows it.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Thank you, sir.
Thank you.
Item 3, Trujillo. Mr. Rennick.
Mr. Trio?
Is he here? Yes. Director True?
I don't see him.
Okay. Go right ahead.
All right.
Let's
Okay.
go ahead and get started. I think there's some questions that we may have for you concerning this case.
All right. Commissioners, Robert Rennick from the Enforcement Division. The department seeks to revoke the respondent's air conditioning and refrigeration contractor license.
Mr. Rennick, just a second. I think that we've already read the case, but is there anyone that's got a question concerning this case? I think there was some, and let me tell you, the confusion that I've got is that it seems like the AOJ was kind of using contractor and technician interchangeably.
We did that in a few places in the PFD.
Okay.
So what do you think? Do you think it's be substantial enough that we should remand it back and have that corrected before, yes? Yeah.
Sure.
Okay. You don't have any problem with that?
No.
Okay.
And that was just a concern that we had, is just to make sure that, like I said, the AOJ seemed to be using that interchangeably.
Yeah.
But I think that we know there's a difference between a contractor license and a technician license.
Right.
And so I think it was significant enough that we feel it should be remanded back.
He did have a technician license before he had a contractor license. And
Okay,
I
so-
think that's what created the confusion with the ALJ.
So did he have a technician license?
The
at
year
this
before.
time? Okay, and then he moved to a contractor license?
And then he moved in, and that expired, and then he got a contractor license. But the
Okay.
notice of hearing only mentions contractor.
Okay.
We just put in evidence of the technician license orally. So,
Mr. Chairman, I have a question for the
Yes, sir,
counselor.
Mr. Shaw.
So did he hold the technician license when he had the contractor license?
no,
Because it says to revoke the
Yeah,
technician.
technician license was expired, and then he got the contractor license.
So maybe, I guess with the kind of following of the necessary, well, it'd be necessary for us to, I guess, to remand it back and then have those technical issues corrected and then
Yeah, we're,
you don't have a problem with that?
the Enforcement Division has no problem with that.
Okay, all right, okay.
Thank you,
I'd-
sir. Motion
okay.
be in order?
I'd move that we, on this item 3, that we remand it back to the ALJ for them to correct the technical issues regarding finding of fact number 1, 6, 9, 11, 18, and 20. And also, I guess, conclusions of law 7 and 12. And modify conclusions of law number 1.
We have
That's
a
my
motion
recommendation.
Second.
and a second. And I think that that's the only thing, in my opinion, that would be cause for concern, is that interchangeable language that the AOJ was using. I agree with the AOJ that it should be revoked, but.
The analysis is the same.
Right.
Yeah,
it is.
yeah.
Technical difference.
It is, so,
Yes.
anyway, so we have a motion, a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to item 5, McKinney.
Is it item 5 or 4?
I'm sorry, item
4.
Well, item 4 should be Vasquez. Let's go to Vasquez. My apologies.
Okay, Commissioners, this applicant seeks a registered air conditioning and refrigeration technician license. In 2008, he was convicted of receipt of child pornography, a felony, and sentenced to 97 months, which would be 8 years and 1 month, in federal prison. He was released in July of 2013. The crime was committed in 2005 when the applicant was approximately 22 years old. He possessed 3,000 to 4,000 images of child pornography on his computer. At the hearing, the department asked the applicant how old the children in the photos were, and the applicant simply refused to answer that question. He did admit, however, that he was capable of teaching himself how to install a video recorder in a bathroom or in an AC vent if he wanted to do that. He also testified that he completed many technical courses and life skills courses while in prison, but he provided no evidence of any kind indicating that he received sex offender counseling. The ALJ recommends that the commission deny the application because of the severity of the crime, insufficient evidence of rehabilitation, and the short period of time that has passed since the applicant was released from prison. The department recommends that the commission adopt the PFD and deny the license.
Any questions, Mr. Rennick?
So move as recommended.
We have a motion,
Second?
a second. Before we move forward, is there anyone here for Mr. Vasquez? Okay. I think there's also some.
We need to make a
correction.
correction on the finding of facts.
Yeah, and I think
Yeah,
it's
there
just
were.
a word that was used incorrectly. I think that under findings of fact one,
Yeah.
they use certified, it should be registered. So it's not a
It's just a
certified
technical, yeah.
license, it's a registered technician license.
Yeah, I
So-
agree to that change.
Okay, so
That's fine.
are you fine with that?
I'm good with that. Good.
Mr. Romo, are you okay with that also? Okay. So we have a motion, and a second, with the change of moving from certified to registered in finding of fact one. All in favor signify by saying aye.
Aye.
Those opposed, motion carries.
Mr.
Item-
Chairman, this is Brad Bowman. Can I just
Yes.
note for the record, there was a letter that Mr. Vasquez provided, and we provided that to the commission,
Yes.
a written statement, and the only, we did redact a portion of it that had information that was not in the record.
Right, and we have that letter before us that was given to us, and it is a redacted email that was sent to us, so. Item number 5, McKinney.
Commissioners, this applicant seeks an apprentice electrician license. Between 2003 and 2007, he was convicted of assault and the crime of evading arrest twice. In each of the evading arrest cases, he was placed on community supervision, but each time his community supervision was revoked. The second one, for which he was placed on community supervision in 2007, he was revoked because while on community supervision in 2008, he committed the much more serious crime of indecency with a child. In 2009, the applicant pled guilty to the indecency crime and was placed on deferred adjudication for 7 years. The victim was a 12-year-old girl. The applicant was 38 years old. While on community supervision for indecency with a child, the applicant committed 3 more felonies. 2 of the felonies, forgery and engaging in organized criminal activity, were related to a large forgery ring involving the Dallas Area Rapid Transit Authority, commonly referred to as DART. The applicant posed as a DART employee and cashed forged checks supplied by an actual DART employee. The check we are aware of was in the amount of $3,300. At least 5 individuals were involved in this organized criminal activity. The forgery and engaging in organized criminal activity crimes were committed only 11 months after the applicant was placed on community supervision for indecency with a child. A 3rd felony was also committed by the applicant while on felony community supervision. It was failure to register as a sex offender, and it was committed about 15 months after being placed on community supervision. On March 1st of 2011, the applicant's community supervision in the indecency case was revoked, and he was convicted of that crime. On that same day, he was convicted of the other felonies of forgery, engaging in organized criminal activity, and failure to register as a sex offender. He was sentenced to 180 days in prison for the forgery and 5 years in prison for each of the other 3 cases in indecency with a child, failure to register as a sex offender, and engaging in organized criminal activity. The applicant was 40 years old when he committed his most recent felony, and he was released from prison on April 18th of 2014. The ALJ recommends that the Commission deny the application because of the severity of the applicant's crimes, insufficient evidence of rehabilitation, and the short period of time that has passed since he was released from prison. The Department recommends that the Commission adopt the PFD and deny the license.
Any questions for Mr. Rennick?
Move that the PFD be adopted as recommended.
Second.
We have a motion, a second. Is there anyone here representing Mr. McKinney?
Bless you.
All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 6, Jerry Nichols. Mr. Foster, come on up.
Good morning, Chairman Arizmendez and Commissioners. I am Ron Foster, a senior prosecutor with the Enforcement Division. I'm here to present the matter of Jerry Nichols doing business as DBL Nickel Electric. Mr. Nichols is licensed as a master electrician, and DBL Nickel Electric is licensed as an electrical contractor. The ALJ has recommended a penalty of $4,000. This enforcement action arises as the result of a consumer complaint filed by Mr. Bilnowski against Mr. Nichols for electrical work which Mr. Nichols failed to complete. Both Mr. Bilnowski and Mr. Nichols testified at the hearing. The judge found the following violations were proved. Mr. Nichols misrepresented the work he would perform, as Mr. Nichols was paid $6,600 to perform electrical work at Mr. Bilnowski's house, which he failed to complete. Mr. Nichols withdrew from employment without reasonable notice, and Mr. Nichols evaded responsibility to a client. Although all three violations were proved, the department only sought one penalty of $4,000 because the violations all stemmed from a single transaction. The judge also found that Mr. Nichols' invoice did not include required information such as the department's contact information and the license number of the electrical contractor. However, the judge assessed no penalty for this violation because Mr. Nichols testified that he had subsequently corrected the invoices. The department recommends the commission accept the PFD as presented with the $4,000 penalty.
Any questions, Mr. Foster? The department initially sought $5,500. Is that correct?
That's correct. That was, there were three different penalties that were sought for different violations with a total of $5,500.
But they're now willing to accept the $4,000.
Yes, the primary one that was proved, well, all three of them that were proved, that were assessed a penalty amount of, I believe, $1,333.33 for each violation. The misrepresentation, the withdrawing without reasonable notice, and the evasion of responsibility to a client, those were all grouped together as one penalty. And then there was a business card violation, which the department alleged, which was not proved. That was $1,000. And then there was the invoice violation, which was proved, but no penalty was provided. That was only $500. We believe $4,000 is adequate.
I move that the recommendation be accepted as recommended with the $4,000 penalty.
We have a motion.
The PFD had no assessment?
The PFD had a $4,000
Oh, it did have
assessment.
4,000,
Yes,
okay, okay,
yes.
I've read it
Yeah.
wrong, okay, I'm sorry.
We have a motion on the floor.
Is the issue still, question, do we have a second?
No second yet.
I'm sorry.
Motion fails for lack of a
So
second.
we'll-
She said.
okay, I'll second it, I'll
She said
second it.
second.
Oh,
I'll
you did
it,
second?
I'll
Oh, okay.
yeah.
I'm sorry. Commissioner Shaw?
Okay, so I have a question for the counselor. Did the ALJ determine that the business card was an advertisement, or did it determine that it wasn't an advertisement?
She decided it was not an advertisement because it was given to a current client and not a prospective client.
What does the rule state?
I'd have to look that up.
Is it not for the purposes?
That is I believe that would be the context that I would put it in, for the purposes of an advertisement,
To
not
solicit
the actually.
business.
To solicit.
Yes,
Solicit
to
business,
solicit.
yeah.
And a
Because we
business
don't have
card.
two business cards, one for current clients and one for prospective clients.
That's correct.
We have a business card, period.
That's correct. That's what I argued, and the business card is specifically mentioned as an advertisement.
Yes.
So I did make that argument, but she didn't agree with my argument.
So
She-
her argument was
that it was provided to a current client to provide contact information because the client wanted to know a phone number or something like that. And so the contractor, Mr. Nichols, he provided that business card to his current client. Now, why he made the business cards in the first place, I wouldn't know, except for advertising, but the judge found that in that particular instance, it was provided to the client, a current client, not for purposes of advertising. So she ruled that I did not prove that violation. And then the invoice was a proven violation, but because he testified that he corrected it, he didn't actually have evidence that he corrected it
So
other
he
than his
admitted the fact
testimony.
that he didn't have it on there?
Well,
when he said he
that's
corrected it.
correct. He testified that he corrected it. Well, we had the invoices in evidence. They're
Right.
part of your evidence, so it's clear that they were not on there.
So by his testimony of saying that he corrected the invoices, he admitted the fact that he didn't have it correct.
That's
to begin
correct.
with.
But the judge found that to be a mitigating factor, and so found no penalty. Again, those were two, in my opinion, minor violations compared to the misrepresentation on the contract.
Well-
So that's where I focused my energies
Right.
on the penalty.
Commissioner Shaw?
I did file exceptions on that, but the judge denied those exceptions.
Yeah, I'll be voting against the motion because I read it differently. When you read 73.51E, it specifically states, and the sentence is broken. So, again, it's basis of interpretation. I'll leave it at that. I feel like, whether a business card is used for contact or advertisement, I think it's used for one purpose and one purpose only, and that's it's a nomenclature. Do you use it for advertising or do you use it for contact? I think it's both. So I'm gonna leave it at that.
So
I
can
think
we-
that the other thing I would, say that with regard to business card is it's universal. But I have, people that are with nonprofits or not people that are retired, and they have business cards, and they're for contact purpose. They're not. I would say that they could be used just for contact information.
But doesn't the rule state that it includes business cards specifically?
Yes.
That's correct, Commissioner
So are you
Rodwell.
concerned that if we just blow this off, we're setting a precedent that somebody doesn't have to follow the rule in certain circumstances?
It's always a concern that a commission decision could be used as a precedent, but you can also indicate that it's not a precedent.
Well, and that's a
That's right.
concern of mine.
That's mine too.
My concern is that we've had issues come up before this commission previously about what is advertisement, what is not. Whether it's on Craigslist, now on this business card, we have held firm that when you're out there soliciting, that's considered advertisement. And I'm with Commissioner Shaw. I'll be voting against this because I think that there's an issue here that we need to address, and in my opinion, needs to be corrected in the PFD to show that there was solicitation. It was an advertisement on the business card because we've previously held firm to that. And I agree is that I'm afraid that we're going to set a precedent here that business card can simply be used for contact information. I don't think that's the case.
I think all of these cases, what we do is, when we have the information and the facts, we consider the facts on the case and the merits of it, and that's what we do. You're talking about, we don't always, but I think that before us and the relevance of the facts and what's presented before us as we consider those when they're presented to us. And when we base our decisions on what's
I agree. And
we do.
And in
We do.
this case, I believe the judge got it wrong.
Well, okay. That's good.
So, Commissioner
I think
Morgan, you
finding
had a
a
question?
No, that-
I'm sorry.
Okay.
I think finding of fact number 10 is the one that you're referring to, and it does discuss the business card and whether or not it was advertising.
Any other questions for Mr. Foster? If not, we'll go ahead and vote on this motion. We have a motion and a second to approve the PFD as presented to us. All in favor signify by saying aye.
Aye.
Those opposed, no.
No.
Motion fails 1-4. I'll now entertain a new motion if possible.
Mr. Chairman,
3.
I think it was
I'm
1-3.
sorry. Well, let's go ahead and take a roll call. I thought it was 1-4.
Luann Morgan,
No.
Fred Moses,
Aye. I think.
Yeah, you and I.
I was an aye. Yes.
Catherine Rodwell,
No.
Robbie Shaw,
No.
Mike Harris Mendez.
No, yes, it was 1-4.
Okay.
I'll now entertain a new motion. Someone wants to
Okay.
take a stab at it?
I'll go ahead and make a motion.
Commissioner Shaw.
I'm going to go ahead and make a motion to deny the PFD as presented by the ALJ, citing conclusion of law number 10, and amending to reflect the violation that was included in there. And as presented by the counselor, I guess the corrected fine then would be, read that number again?
Well, finding of fact number 10 states that a business card did not include electrical contractor license number, which was alleged, but then concludes that it was not intended as advertising.
And we have
So
to
that would
conclude
be
that
the
it
one you
was
would-
intended.
Conclusion of law.
So we need
Yeah.
to change that it was intended for advertising. Now, are you looking at a change in the fine?
Finding, yeah.
Or the fine amount?
No, changing the conclusion of the law.
Yeah.
Right, no, I'm asking if he's asking for a change in the fine
Yeah, I was
amount.
asking for the change of fine too. I was going back to what the original fine was.
55.
That, the department had sought a $1,000 penalty for that
benefit for
violation.
that.
It's a Class B violation.
I'd like to change that fine from 4,000 from what the ALJ had recommended to the $5,000 fine. That would include the $1,000 for the business card.
And 1,000 is the minimum for, it's, for a Class B violation, it's 500 to 3,000, so it is on the lower end of the scale for
The
that.
1,000.
So you want to do 500 or 1,000?
1,000. I got it.
So,
And the invoice that was corrected was a $500 penalty that was sought on that. And it was proved, however, because corrections were made to the invoice, the judge decided not to provide a penalty for that.
Oh.
That was a Class A violation.
but they were found guilty of it. She just failed
That's
to fine
correct.
them. Okay.
And that could be penalized from a reprimand up to $1,000, and I sought 500, which was right in the middle.
You're
that
going for it all,
violation.
aren't you?
You seem amenable.
So we have a motion to deny, and actually to amend the PFD, is
Amend
what
the
we're looking
PFD.
at.
To 5,000?
And,
5,000.
I'll second it.
okay, and a second, which is basically changing conclusions of law 10 to say that respondent did violate the code, and then changing the fine amount to 5,000. Is that correct, Brad? Okay.
That's, from my perspective, that's correct. This is Brad Bowman, General Counsel.
Any questions, comments? All in favor signify by saying aye.
Aye.
Those opposed?
No.
The motion carries 4-1. Let's move on to item 7. Thank you, sir.
Thank you.
Mr. Thielen. RV. Anyone here representing Randall RV? Go right ahead.
Good morning, Commissioners. My name is Trevor Thielen, and I represented TDLR at the SOA hearing against Randall RV, where I presented evidence that Mr. RV both advertised and performed unlicensed air conditioning work in July of 2014. The ALJ agreed with my recommendation that you revoke Mr. RV's ACR technician license and assess a $10,000 penalty. That is a serious penalty, but also an appropriate and necessary one, since the facts of this case are especially egregious. Over a year before the July 2014 violations, we received multiple complaints about Mr. RV for advertising unlicensed ACR work on Craigslist and another website. In March 2013, a TDLR investigator sent Mr. RV a letter which specifically quoted the ACR law requiring an ACR contractor license to perform and advertise ACR work, and stated in plain language that his advertisements were violating that law. We know Mr. RV received this letter because he emailed the investigator back 4 days later and stated he was aware of the investigation and of the law. yet his advertisement still remained up. The investigator pointed out this continuing violation to Mr. Arvey in a reply email, which we know he received because he replied back to it. And once again, Mr. Arvey did not take down his advertisements. Instead, Mr. Arvey doubled down. Less than 3 months later, on June 1st, 2013, he installed an air handler in Houston for $1,900, a job which he could neither contract for or perform without an ACR contractor license. In July of 2014, I worked on these earlier cases, and I spoke with Mr. Arvey extensively about them and the licensing laws. We worked together to finally get Mr. Arvey's website advertisements taken down, and the phone logs of our conversations, all entered into the record in this case without objection, make it clear that Mr. Arvey knew in February 2014 that he could not advertise or perform ACR work without getting an ACR contractor license. But just 4 months later, in July 2014, in the instant cases, Mr. Arvey did both of those things once again. He went to the home of Rosa Zentano in Richmond, Texas, and presented a business card stating that he owned and operated an AC and heating company. He then installed an evaporator coil and got paid $760. The coil leaked and damaged Ms. Zentano's ceiling, but Mr. Arvey refused to pay for the repairs. Instead, Ms. Zentano had to pay an additional $1,400 to a licensed ACR contractor to replace the leaky coil. The 3 older cases involving the website advertising and unlicensed ACR work in 2013 went to a default order. The penalty in that case was $10,000. This time we are asking for another $10,000 penalty and revocation of his ACR technician registration because every enforcement plan factor weighs heavily against Mr. Arvey. These latest violations are serious and they cost Ms. Zentano a lot of money. The extensive evidence that Mr. Arvey knew he couldn't advertise or perform unlicensed ACR work before he did just that shows that the latest violations were both willful and intentional. Mr. Arvey didn't act in good faith to avoid the violations or to mitigate them when Ms. Zentano asked for help repairing the damage his unlicensed work caused. Mr. Arvey has engaged in these exact same violations in the past. And finally, with regard to what level of penalty or sanction is necessary to deter future violations, I think the ALJ put it best, quote, because respondent seems incapable of limiting the scope of his activities to those that he is authorized to perform under his ACR technician license, the recommendation by staff to revoke that license is reasonable. We recommend that you adopt the PFD as written. Do you have any questions that I can answer?
Any questions, Mr. Thielen? Motion be in order.
I move that the PFD be adopted as recommended and that conclusions of law number 1 be corrected to specify occupation code 51 and 1302. And conclusions of law 6 be corrected to cite operational chapter is 1302. And that amend the conclusions of law 7 to correct the enforcement plan for the second time Class C violation.
Second.
From a motion and a second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 8, Cunningham. Mr. Thielen.
Good morning, Mr. Commissioners. My name is Trevor Thielen. I represented TDLR at the SOA hearing against Cody Cunningham. TDLR contacted Mr. Cunningham because he posted a Craigslist ad which stated that his company, Cunningham Construction, specialized in electrical work, among other things. A TDLR investigator contacted Cunningham posing as a potential client looking for electrical work. Mr. Cunningham sent the investigator an email proposal to install ceiling fans and electrical outlets for $1,550, not including the price of materials or permits. Sending a written proposal for installing ceiling fans and outlets is an offer to perform electrical work, and you can only make such an offer under an electrical contractor license. But Mr. Cunningham does not have an electrical contractor license. The ALJ considered the range of penalties for unlicensed electrical contracting, which in this case was $500 to $3,000. The ALJ concluded that, while this was a first-time violation and Mr. Cunningham changed his advertisements, it was also a serious one. After considering all the factors, the ALJ found TDLR's recommended penalty of $2,000 to be, quote, moderate and reasonable, and agreed with it. We recommend you adopt the PFD as written. Do you have any questions I can answer?
Any questions, Mr. Thielen?
Move to adopt the PFD as presented.
Second.
We have a motion, a second. Is anyone here representing Cunningham Construction? All in favor signify by saying aye.
Aye.
All opposed? Motion carries. Commissioners, if you're okay, we'll move on with motions for rehearing. So we won't take a break just yet. Let's go on to H, motion for rehearing. Number 1, Angel Rodriguez. Ms. Lindquist, come on up.
Good morning, Commissioners.
Morning.
Della Lindquist, Deputy General Counsel. In this first matter, notice was good and it was delivered. Mr. Rodriguez has called and entered into a repayment plan with the General Counsel's office and is current on that plan. Therefore, we would recommend, because there was no error, denying the motion for rehearing, but you could, in keeping with what you've done before, probate the revocation for 1 year, provided he stays current on the payment plan.
Payments. Is there anyone here for Mr. Rodriguez? Commissioners?
Move that we adopt the recommendation the proposal as recommended.
To deny
To
and
deny
probate.
and
probate.
probate
For 1 year.
1 year, after 1 year. Thanks.
We have a motion on the floor.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2, Wooten.
Mr. Wooten's case was heard before SOA. You've seen this case before. We made a small technical correction to the PFD, reissued the decision, and that's why this second motion for rehearing is before you today. Mr. Wooten only alleges in his motion for rehearing that he should be granted a second chance. In all other circumstances, you had agreed with the ALJ to revoke the license. We see no error and recommend denying the motion for rehearing.
Commissioners, any questions? Recommendation by General Counsel is to deny the motion for rehearing.
So moved.
We have motion and a
Second.
second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 3, I think we do have Ignacio Zico. Okay, if you want, you can come on up here and have a seat.
And we do have someone to help
An
translate
interpreter.
for him.
Come on up.
Irma Mendoza.
Go ahead, Della.
Basically, this is an unlicensed barbering case, and Mr. Zarco alleges that he was not actually committing or performing unlicensed barbering, but he was in the process of trying to apply for a license at the time when he was standing in the salon. However, notice appears to be good. We mailed, he subsequently did get a license about a month or 6 weeks after this appearance, when our inspector or investigator saw him. He did fully get the license. However, and so we mailed the notice to the license, to the address when he applied for the license, so we believe notice was good. He may have some things to say in line with his motion for rehearing, but we recommend denying the motion for rehearing because notice was good. He was there in the salon, according to the pled facts, he was getting ready to perform some unlicensed barbering before he had a license.
Okay. Any questions for Ms. Lindquist?
Do we have a translation of this letter that we were?
I don't believe so.
I thought we did.
I don't
believe we
think
got
I
it.
have one.
We do. You should have received it. Would you like me to make you some copies?
Mhm.
Right, sorry. Can someone make some copies?
Just kind of say, it is kind of a long letter, so why don't we take about a 10-minute break in order for them to be able to get copies and get it to the commissioners. They have time to read it before we take this up.
Okay, we can go to the next one.
Yeah, why don't we just do that? Let's just do that. Why don't we just move on to the next one? Just let them know, we're going to move on to the next item, so in order to give time to go on to the next one.
There's 2 pages.
Okay. Item number 4, Lydia's Beauty Salon.
In this case, she just alleges that she thought she had taken care of the payment. We had inquired if she wanted to enter into a repayment plan with us. She has not at this time. Notice was good. She just alleges that she was confused. We recommend denying the motion for rehearing.
Okay. Anyone here representing Lydia's Beauty Salon? Commissioners, the motion will be in order.
So move as recommended.
Second.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 5, Nail Boutique.
In this matter, the respondent does allege that she was not the owner of the salon and has never been the owner of salon. Our records do indicate that there was another owner of the salon at the time this took place, and we recommend granting the motion for rehearing.
Any questions for Ms. Lindquist?
So move. That
We have a
Second.
motion and a
Grant the motion.
second. Anyone here representing Nail Boutique?
That we grant the motion for rehearing.
All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Commissioners, you have the letter in front of you now, so I'm going to keep going. I'll give you time to read that here in just a bit. Let's go on to item number 6, Sky Nails Spa.
Respondent alleges that the only reason he didn't handle this matter is because the department gave him incorrect contact information to settle it. However, there was a typo in one of the phone numbers, but this respondent had plenty of emails and other opportunities to try to deal with this matter, so we recommend denying the motion for rehearing.
Anyone here representing Sky Nails Spa? Commissioners, motion be in order.
So move as recommended. That we deny the motion for rehearing.
We have a motion
Second.
and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's go on to item number 7. Is it Davi 2427?
Yeah, Nancy Nguyen,
Uh-huh.
Davi Nails.
Davi
yes.
Nails.
She simply alleges some defenses to the allegations. However, notice was good. Notices were mailed to the correct address and were unclaimed. We recommend denying the motion for rehearing.
Anyone here representing Davi Nails? Commissioners, motion to be in order.
Second.
Motion is second. All in favor signify by saying aye. Those
Aye.
opposed, motion carries. Item number 8, Cradle Enterprises.
This is an EAB case. The respondent does allege a technical error in the default order, that the project number was written incorrectly. We can make a technical correction and reissue the order, but we don't believe there was any substantive error that would warrant granting the motion for rehearing. So what you could do is deny the motion for rehearing and instruct the executive director to just reissue that
Corrective
corrected order. We can do that.
So move as recommended.
We have a motion.
Second.
A second. Anyone here with Cradle Enterprises? Or Credo Enterprises, I'm sorry. All in favor signify by saying aye.
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 Those opposed, motion carries. Item number 9, Michael Leaguer.
Mr. Leaguer or Leger alleges that
Leger.
he actually wasn't misrepresenting on his renewal application, that the conviction for his felonies came subsequent to his application. However, a review of the record indicates that his convictions were in April of 2014, and he filled out the renewal application in October of 2014, so he did misrepresent. So I'm not sure why he's saying what he said in his motion for rehearing, but we believe he's incorrect, and we recommend denying the motion for rehearing.
So move as recommended.
Second.
Motion, a second. Anyone here for Mr. Leger? All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 10, Carlos Rodriguez.
Mr. Rodriguez offered some defenses to the allegations. However, the notices were sent to the correct address. He alleges that he subcontracts the work out, but we see no error, and we recommend denying the motion for rehearing.
Motion will be in order.
So move as recommended.
Second.
Motion, a second. Is anyone here for Mr. Rodriguez? All in favor signify by saying aye.
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 Those opposed, motion carries. Commissioners, since we've been going through this, I haven't had a chance to read this. Let's go and take a 10-minute break, and that gives the commissioners time to be able to read this letter. And then we'll come back and take up item number 3, Sanchez Zico. still put Junio up there.
Yeah.
Instead of June.
Here you go, Robbie. This is kind of interesting.
You know Michael Kelly?
Yeah, we have. Yes, thank you.
You want one? I need a pen. I don't see a pen.
You know what, you would really like the way it writes beautifully.
Well, it's nice. Yeah, I need a pen.
Use your pen for it.
Oh, go ahead. You can have it now. I've got another one.
You have? Okay, is that right? Okay, all right, okay.
He's gone for 2 years. Let's get it. I don't think we received notice to relate to
Some of
Soleil.
these must have been.
He's out of the country for 2 years. Yeah, I have a home warranty on this home that I bought in Irving, and so I had problems with the air conditioner. They sent this guy out, and turned out he said, older air conditioner. He said, air conditioner worked fine, but it doesn't. Drain pipes, drain pipes leaking about 2 months. So I had to tell the home warranty company it's gonna be $2,900, and the home warranty company said, well, I said, well, it's not one thing, it's one other choice for you. It's okay. They came up to work, and I said,
Well, he always said that he never found.
No, I thought. But no, what I heard.
Was he?
That he is that it's only in favor.
Right.
He never bet against the bet.
Yeah. Originally his statement was, I only bet on games that take place. And then we later found out, like, that doesn't say that any games. He's like, well, no, I never bet against them. So I've never grown.
Man, I love this.
You know, it's just, he was separate player from the person in his weekend, no doubt, because he was really not but it wasn't like he was a superstar in the sense that he had all this talent. He just was a blue collar.
He was a gritty.
Gracias. ¿Quiere agua?
¿Mande?
¿Agua?
No, no, gracias.
A ver. Así.
¿Me van a preguntar algo primero o...?
No sé. Ahorita a ver cómo.
It's now 9:35. Let's go ahead and bring this meeting back to order. Let's go back up to item H3, which is the motions for rehearing for Ignacio David Sanchez Zico. And Commissioners, you've had a chance to read the interpreted or the translated version of the letter that was sent to us. Real quickly, who interpreted this? Was it somebody from our agency?
Yes.
We did? Okay. Was it you? Okay, I just wanted to make sure. That way, if anybody was asking questions, we know there was somebody from the agency that interpreted it, so. Okay. And it's actually the individual that is the interpreter for Mr. Sanchez Zico right now,
Correct.
too, so Irma Mendoza, so. Ms. Linkwitz, go right ahead.
Okay, if you've read this, you'll see that he alleges that he was not performing or offering to perform unlicensed barbering at the time, but applying for a license. He was issued a license about a month or so after this inspection. We used the address of record that was the correct address when he applied for his license, so it was the current address. So we believe there's no error and that he had the opportunity to be heard. So we recommend denying the motion for rehearing.
Any questions for Ms. Linkwitz? Mr. Sanchez Zico, if you don't mind, have him state his name for the record, please.
Diga su nombre para el record.
Buenos días. Mi nombre es Ignacio David Sánchez Zarco.
Okay. He can go ahead and present his case now.
Okay. ¿Qué es lo que quiere presentar al comisión?
Mire, mi apelación es de que se me está haciendo una multa que para mí no es no debería, porque me están multando de que trabajé en un lugar sin licencia. Y cuando yo llegué a ese lugar, nomás fui a pedir información para ver si podía yo sacar licencia de Texas con mi licencia de California que está vigente.
Okay, permítame, deje traducir.
¿Cómo?
No, perfecto. Mi caso es que tengo un problema.
That was good.
Normally I do this.
You go the other way,
That
right?
way.
I'm sorry.
I'm sorry.
Yeah, you need to go back this other way.
See, this
Turn
is
the
what-
car
okay,
around, go
now
back.
I feel better. Okay, my motion to be here right now is because I think the fine that was given to me for $1,500 is unjust. I was at a place on a beauty salon asking for information on how to obtain a license since he had a current license in another state. Okay.
Cuando llegué al salón, había dos personas y una mujer me preguntó que cómo me llamaba. Y yo por respeto les di mi nombre.
Okay.
¿No?
No, déjeme traducir.
Okay.
Okay. When I got to the shop, there were some people there. There was a woman that asked me for my education and if I had a license, and because being cordial, I went ahead and told him yes, that he was looking for a job.
Remember, if you don't mind, and I failed to mention this, let him know that the only thing that we can take in consideration is those things that were presented. Is this a default case?
Yes.
Okay, never mind. Go ahead.
Okay. Nomás pueden tomar lo que...
It was not a case that went before SOA, so never mind. I
The real-
thought it was a SOA
The real
case.
issue in a default, again, would be notice.
Mhm.
Not so much of course, he can talk about some
the facts of it,
circumstances of
right.
what happened, but not really speak to the issue of whether he was barbering or not barbering that day.
Just that he received notice.
Did he receive the notice and have the opportunity to respond to
Right.
the allegation?
Ask him that
Okay.
question, if he actually received the notice.
No puede traducir todo como ellos creen que todo por presentar su caso. ¿Quiere saber si recibió la carta?
Okay.
Porque este ya no es un caso de decir si estaba ahí o no, si recibió la carta.
Oh, pues la recibí apenas este año.
He said he did receive it because he has it right there.
So he did receive the notices.
Mhm.
Well, did he know what to do with the notice? What did he do with the notice when he got it?
Cuando recibió la noticia, ¿qué hizo con eso? La primera carta que
La
le mandó.
primera carta, hablé para acá para que me informaran de qué era la multa, porque yo no sabía de qué era.
He called the TDLR to find out what the letter was about because he didn't know what the fine was.
Y la multa era en el 2013 y yo el papel lo recibí en el 2015.
He said the fine was assessed in 2013 and he received the letter in 2015.
We may be talking about different notifications. The notice of alleged violation, the first indication from our enforcement division that he did something wrong, went out in September of 2014.
Ok, la primera carta que ella está hablando es de septiembre del 2014 del Departamento de Enforcement.
Ajá.
¿No lo recibió?
Does he remember that
No,
letter?
lo que pasa es que yo vivía en una casa y ahí me fui a México y ya nunca supe, pero el tiempo que trabajé, cuando llegó mi licencia, nunca me llegó.
He said that he never got the first letter because he went back to Mexico for several months.
But we had the correct address on file.
We used the address,
Tenían la
in other words, he
dirección
did
correcta.
get a license about a month after this inspection or investigation, and we used that address that had never been updated until just maybe a few weeks ago. So we used the address of record, which is what we're required to do. The issue will come down to, he claims he was in Mexico at the time.
Okay. Ella está diciendo que la dirección que usted tiene aquí es el que estaba en record, aunque usted está diciendo que estaba en México en ese tiempo.
No, bueno, es que yo en octubre del 2013 me fui a México.
Okay. He just saying he left to Mexico in October 2013. So,
But the address is still correct. It's
La
2621
dirección estaba
Langford
correcta.
Street in
Sí,
Greenville.
Yeah, the address is correct.
Vivía yo en 3307 Barling Street de Greenville, Texas.
Okay.
yeah.
Vivía.
In all fairness, we mailed it to Barling Street, which is the address that he used when he applied for his license.
Barling Street.
Mhm.
That's what he just said, that's what he.
Yes, I guess the other side of it is whether we could, let's say, when we have, and it was a default, so he got something he didn't respond to, and whether he said he called, but the issue is whether, you know, is there somebody in enforcement works with people like him to make sure that he understood what he had. And I guess the other issue, whether we can if we grant the motion for a rehearing, whether there'd be an opportunity in enforcement to have somebody work with him to have a better understanding of what happened.
Okay.
What-
Él estaba diciendo que quiere saber si el departamento
And that's
de-
more of a
de
question
defensa de
for Della
nosotros,
than
y
him.
usted entiende que era la razón que le dieron la. Okay.
No, es que, ¿cómo le diré? Mire, mi licencia a mí me llegó en abril del 2013. Y está diciendo que el papel nos mandaron en el 14.
Okay, he said he received his license in 2014.
Mhm.
And he still has a problem with a letter that he never received, even if it was a correct address in 2013.
Well, and I understand he's saying he didn't receive the letter,
Mhm.
but the fact was that he was in Mexico.
Right.
And the letter still went to that address, which is the address of record. And if he had changed his address to Mexico, then it would have been a different story, but he didn't. So the letter went to him, and there's nothing we can do about that he was gone. That's not our fault.
Okay. No es culpa de la comisión si la carta se fue a la dirección correcta y usted no cambió la dirección a México. Si lo hubiera cambiado a México es otra razón, pero se fue a la dirección que tenemos en record y así está.
Bueno, una defensa es, me tocó en Los Ángeles, California, ver un inspector en un salón, en una barbería,
Yeah.
levantando un ticket. El
California doesn't matter. does it?
Right. Él no quiere, en California es otro estado, no.
Ok, pero me refiero que el ticket allá se lo dieron al dueño del salón, no al barbero. Y aquí al dueño del salón no le dieron nada.
Okay, he's also concerned about he's saying California finds the salon owner also, not just the individual, and here in Texas, we only did a
Well,
fine to him.
we're not in California.
So,
Did he
no
make
está en
arrangements to have his mail forwarded to him if he was leaving for many months?
¿Hizo algún cambio de dirección o algún arreglo con alguien que le llegue su correspondencia?
Sí.
cuando se ve?
Sí.
He said yes. He had an arrangement. What do you have?
This mail the NOAV went out September 29th, 2014, to his address on Barling, which is what was in his application for a license. and it went unclaimed October 21st, 2014.
So it wasn't forwarded,
Apparently not.
right, if
And-
it was unclaimed.
Ujú. En el 2013 y el 2014, cuando estaba en México, no cambió
Is
la
it
dirección.
certified when
porque
they
no
go
les-
out?
no le
No.
cambiaron.
So
Yeah.
that means it can't be
No, apenas la
forwarded,
cambié
right?
en-
They won't
en
forward a
este año.
certified letter?
I don't know that.
I don't know that either.
I don't either.
Chairman.
Yes, Commissioner Shaw.
That's correct, it cannot be.
Go ahead, Mr.
It's our understanding from our GC office that it cannot be forwarded if it's certified.
Commissioner Shaw.
So I have two questions for Della. First question is, when the inspection was done and when the applicant was confronted about his license, was that at the Langsford address or at the Barling address?
I'm sorry, what was your question?
When the applicant was asked the question whether he had a license or not by the investigator, was that done at the Langsford address or at the Barling address?
It was actually at the salon. That's on Wesley Street in Greenville, Texas. Sandra's Beauty Salon was apparently where he was encountered by our inspector in March 2013. But at the time, he applied for the license, which was right about then or a month later. It was Barling, and that's the address that was used to send out the NOAV because that was the most recent address at the time. He may have since updated his address after talking to GC to mail the order to. But for the NOAVs and the other things, they used his most recent address of record, which was Barling Street.
I have a follow-up question, and this may be something to do with the executive staff. When a local address here, if the applicant is living overseas, does the mail get forwarded to an overseas address? Does anybody know here?
It says that
I'd like the executive staff to answer that question.
We don't know, but I think that would be upon the person to set whether they're forwarding it. We're not initiating anything on our end to make sure that's forwarded there. We send it to the address of record, and that accomplishes our requirement.
I'm going somewhere with this, and that is, does a local mail, if there was a forwarding address overseas, does the United States Postal Service forward that memo or the letter or whatever that is to an overseas address? And I'm questioning that because, we've been told that the address was given to the post office for forwarding. So I'm just questioning that. I'm just trying to clarify that
don't
in my
know.
mind.
But I
Okay.
think what we said is that it wouldn't have, even if he had a forwarding address, it wouldn't have been forwarded, I think she said, because it was certified. So it could not have been forwarded regardless.
Possibly. I
Uh,
don't know.
that's-
He did not allege in the motion for rehearing anything about forwarding. This is the first time it's
Okay.
come up.
This is Brad Bowman, General Counsel. I just wanted to chime in. This is some information from the Enforcement Division. that Ron Foster just told me their procedure in enforcement is if a certified mail letter is unclaimed, if it's returned to the department with a forwarding address, then enforcement's procedure is to send the notice to that forwarding address in addition to the address of record. And I don't know if that happened here, but that's just kind of the standard. Just to answer your question,
you.
that's sort of their standard.
We do have a
procedure.
process in place,
Yes.
basically. Thank you.
Well, I guess the question, there are issues of, I would think, with the applicant, whether there's an issue of, even if he got the address, whether he had enough information or have enough support to understand what was happening, and whether there would be an opportunity for, if we grant the motion for a rehearing, whether there'd be an opportunity for him to work with enforcement to get this resolved. So
Is that a
Yeah.
question for me?
Yes, yes.
If you grant the rehearing, essentially it vacates this order, and it would be up to enforcement to reinitiate the case if they chose to, another NOAV.
But he has a license now. If they wanted to, they could.
Yes.
I would be inclined to grant the motion for rehearing and give the enforcement opportunity to work with him. So I'd move that. That's my motion. My motion is to grant the motion for rehearing to give enforcement an opportunity to work with it.
I second that.
We have a motion, a second.
Discussion?
Yes, I still have a question myself. Has there been any discussion made, or has, let me ask this to Mr. Sanchez Zico. Has he had any attempt to try to put this into payment plans whatsoever?
¿Alguna vez hizo usted algún arreglo para hacer un plan de pagos?
No.
No.
And so we've never received information from him to try to move this into a payment plan resolution?
No.
Okay. Mr. Shaw?
Well, thank you. After reading the letter and understanding where the applicant is coming from, I think the motion for rehearing is basically to do with a reduced penalty. That's where
I think so, too.
That's how I'm understanding it. And if that's the case, is that something that we can work with the applicant directly if the commission so desires?
If you believe that he didn't receive the notice, or if there was an issue with the notice, I think rather than reducing the penalty, we try to avoid reducing penalties at the motion for rehearing stage. That's not really the appropriate for here, but if you believe the penalty was too high, or you believe there wasn't any proper notice, or there was some question, the more appropriate thing would be to grant the rehearing.
Mr. Chairman, if the motion for rehearing was granted, that gives the executive director to work with the enforcement staff and the respondent to get a lower penalty that would take care of this matter.
That's right.
We can dispose of it that way.
I just wanted to hear from the motion maker that that was the intent of the motion, that it was for a reduced penalty and not because there was some discrepancy in the mail and so forth. So, back to you, Mr. Chairman. Is the intent of the motion maker to have a reduced penalty? If so, then I would be in support of the motion. If not, then I wouldn't be.
My intent of the motion is that enforcement and executive director have an opportunity to work with the applicant to resolve this. And that could include, that can include all the tools available.
Commissioner Shaw, that's my understanding.
That was
of the
his.
discussion, and that's my
Yeah,
philosophy.
that's right.
I'm just trying to
Department of
pin-
Licensing, I want to make sure that this
Yeah.
individual's licensed and
Yeah.
a nominal penalty to correct this is appropriate.
Sure.
Very good.
Any further discussion? We have a motion and a second on the floor. You might let him know that we've closed discussion now, so.
Okay. But what is gonna be, what am I gonna tell him that is gonna be? The motion for rehearing?
We don't know yet.
We don't know
Yeah.
yet? Okay.
Yeah, we'll tell him in just a
So,
second.
it's
We have a
tan
motion,
sencillo-
a
tan
second
sencillo
to
que lo que van a hacer todavía.
grant
Para no
the
decir
motion for
que quieren
rehearing
decir,
and
bueno,
remand it back to
para
enforcement.
enforcement.
And I'm assuming it's to turn around and work with enforcement and the
Whatever
executive
they do,
director.
that's right.
And just send it back to them. Is that correct?
Yes.
Okay.
Yes.
We have a motion, a second. All in favor signify by saying aye.
Aye.
Those opposed? Motion carried. Let him know that we're remanding it back. We've granted the motion for rehearing,
Okay.
and enforcement will be in touch with them.
Ok, el departamento de enfoque le va a dar otra carta a usted y le va a decir cómo van a hacer el caso. Listo. Ok, y que verifique su dirección más corriente. ¿Es esta? ¿Cuál es la dirección?
Quiere esta porque luego yo
¿Esta es la
puedo
nueva?
salir. No tengo, estoy viviendo en otro lado, pero me puedo cambiar. Mejor
Ok,
esta.
trae sus cosas.
Gracias. Let's move on to item I, the penalty metrics for the ACR contractors. I guess we've got a pony show that you're going to show us, a dog and pony show?
On the bottom of the screen.
Good morning, Mr. Chairman, Commissioners. I'm Christina Kaiser, Director of Enforcement. At Agenda Item I, you have a draft of a revised penalty matrix for air conditioning and refrigeration contractors. Just by way of background, the penalty matrix has several purposes. It is published and it is used to put the industry and the public on notice of the possible penalties or license sanctions that a person is subject to if they commit violations of the air conditioning statute or rules. Within the Enforcement Division, the penalty matrix is used as guidance for the prosecutors. Whenever the prosecutors are seeking formal enforcement action against someone, when preparing a notice of alleged violation, the prosecutors will consult the penalty matrix to determine what penalty or license sanction to pursue for a particular violation. The matrix is not binding on you, of course, or on the executive director, but it is generally binding on my prosecutors as a policy of the Enforcement Division. The penalty matrix for air conditioning contractors was last published in July of 2012. We have recently updated the matrix to bring, with me is Chris Russey.
Hey, Chris.
Chris is the Research and Analytics Specialist for the Enforcement Division. He is the person who does the actual hard work involved in updating the penalty matrices.
I wonder if you're just going to let him sit there.
Right. And he is helping me today. He has a copy of the matrix up on the screen for the audience to see, and we also have the statute and the rules available to pull up if you have questions about any particular provision that's referenced in the penalty matrix. We have updated the matrix to bring the violations and the citations in line with the current statute and rules. Specifically, that includes changes that were brought by Senate Bill 383 in the 2013 legislative session, which repealed the provisions in the statute relating to the sale and use of refrigerants, and then 2 sets of rule changes that followed after that in January 2014 and August of 2014. Beyond the statute and rule updates, we've made a few other changes. We've done some general cleanup to improve the way some of the violations are stated. We've added subject matter headings within each class to make it easier to find a particular violation. We have made similar changes to other matrices over the last few years, and those have been very well received by the industry. So we're hopeful that the same will be true here. We have moved 1 violation to a higher class. Overall, these are not significant changes to the matrix. The Air Conditioning and Refrigeration Advisory Board recommended approval of the matrix on September 8th of 2015, and today we are requesting that you vote to approve the matrix to be published as part of TDLR's enforcement plan. I will walk you through and point out the substantive changes to the matrix if you would like me to do that. There are not that many. In Class A of the matrix, we the first violation you see there struck through was removed because, as I said, the refrigerant provisions were removed from the statute. Under administrative violations, the 5th bullet, we added a violation that had been in the rules for a long time. It's not new. We had simply failed to include it when we did the matrix last time. Under Class B, you'll see a violation struck out, failure to provide direct personal supervision. This is the 1 violation that we have moved to a higher class, and we'll show you that in a minute. I'm going to skip over all the all the changes that are simply cosmetic changes to language, as you'll see there under administrative and records violations. In Class B, on the 3rd page of the matrix, you'll see there's 1 violation that's characterized as a mechanical integrity violation, and we struck the language or call for inspection. The violation used to be failed to obtain permit or call for inspection, but we've struck the calling for inspection part. And this is because my lawyers have scoured through the applicable codes, and calling for an inspection is not actually a stated requirement in any code. It is a process that happens when people interact with city regulation, but it is not actually a requirement stated in any code, so we're taking that out. In Class B here, also on the 3rd page, you'll see we have the less serious forms of unlicensed activity, such as performing outside of your license classification or while your license is expired. We've talked about this distinction when addressing other matrices. The less serious forms of unlicensed activity here we think are less serious because these are people who have licenses or who have had a license in the past, so we feel that they're probably more knowledgeable and less likely to create serious havoc for a consumer. You'll see that we've added at the bottom of unlicensed activity performed non-exempt duct work. we actually need to add a few words there, without a license. I don't know how we got all the way through the advisory board meeting without noticing this, but we need to add without a license. This violation reflects a provision in the rules that says you can, without a license, do A, B, C, and D that is in the form of duct work. But if you go beyond that, then you have to have a license. So that's what this is about. It's sort of a back-end way of getting at the violation. In Class C, you'll see another refrigerant-related violation was struck. Under mechanical integrity violations in Class C, you'll see the one violation that we moved up from Class B to Class C. The very last one listed under mechanical integrity violations failed to provide direct supervision of all work requiring a license or registration. We think that's kind of a big deal, and we think that's the same level of seriousness as violating a code, violating an ordinance, failure to provide proper installation according to manufacturer's instructions. All those other things that are in this same category. Under the category of misrepresentation on this same page, the second violation, this again is simply clarifying language that was already in the rules. It's been in the rules for a long time, but we simply added some words to more fully reflect the violation as it exists. Here also in Class C, you'll see these are the more serious forms of unlicensed activity. These are the truly unlicensed individuals. And then finally in Class D, the very last violation listed in Class D has to do with a dishonored check. If a person applies to the agency for a license and pays with a check, if that check bounces, our finance division makes effort to try to get the person to pay it back. If they don't, then they will refer the matter to enforcement, and we make multiple efforts to get the person to pay it back. Ultimately, if the person continues to thumb their nose at us, then our theory is they haven't satisfied the requirements for the license because they have not paid the fee, so we seek to revoke the license. That rule that sets out our authority to do that was recently, in October of 2014, expanded to recognize other forms of payment such as credit cards. So we changed the word from check to payment. That is the sum total of all the substantive changes to this matrix. I'm happy to answer any questions you have, but I'm asking that you vote to approve the matrix to be included in the agency's enforcement plan.
Commissioner Shaw.
Yeah, I don't see anything that stands out as drastic as one would think with all the changes. I think it's very relatively straightforward. I did have a question on Class C. If you can go down to misrepresentation, second to the last bullet, subcontracted design to an unlicensed person. Are you referring to design of an HVAC system, design of a refrigerator system? I feel like that's sort of left unclear there.
That's actually under the category heading of unlicensed activity, and the rules are specific that you cannot subcontract the design of an air conditioning system to an unlicensed person. We can pull that rule up if you want to look specifically. There are two.
But you just said it is about air conditioning and refrigerating systems.
Yes.
Okay. I just thought it would be wise to add just that in there so it's clear that you're referring to the design of that and not any other components.
Okay.
I don't want the agency to get challenged over something that, you know, is very straightforward in the rules.
Okay. And we're happy to make that change. Just a reminder, though, this document does not create the law.
Correct.
This simply lifts the violations out of the statute or rules. So these are our paraphrasings of those. The statute or rules would actually be the language that the person would have to challenge. But we're happy to make that change because it does clarify.
And I would go ahead and make that same change also that you talked about under 75.10 under Class B, without a license. That needs to be added in there.
Yes, sir.
Other than that, I don't see any other changes.
So you want this effective, what is it, you'd like to have done?
Your approval of it would be effective today. There doesn't have to be an effective date really because this is not a rule package. As soon as you approve it, then the next step is that it gets published to the world in the Texas Register and also on our website.
So I'd make a motion that we approve the enforcement plan for air conditioning and lights, effective immediately, as recommended
Second.
by enforcement.
We have a motion, and a second, and you said that the ACR advisory group approved this when?
September the 8th.
Okay. So it's been vetted through them? Okay.
Yes.
All right.
Yeah, if both the motion makers can agree with those two changes that I proposed.
Yeah.
Oh, yes.
It is.
Yes.
Yeah, we're.
All in
as
favor signify by saying aye.
Aye.
Those opposed, motion carries. Great
Thank
work.
you.
Thank you very much.
Appreciate it.
Thank you very much.
Move on to item J, an update from the executive director on our continued revenue riders.
Mr. Chairman, Commissioners, we are still having discussions with the staff at the Comptroller's office about the certification of the appropriations in the rider to Senate Bill 202. That rider would give us the appropriations to implement the transfer of those Department of Health Service programs over to us. So that ongoing discussion it's frustrating, and it is delaying the target date that we have for implementation of that transfer. The current transfer target, as we discussed with the Department of State Health Services, was March the 1st. But as we keep going further and further before we get the certification of those appropriations, it will push back our ability to meet that timeline because that transfer is contingent on us doing certain things to make sure that it works smoothly. Specifically, hiring the individuals that will be implementing those programs, and we have to be able to do that. There's a lag time in doing that. I can't go out at this point in time, post and hire those individuals if we don't have the certification of the appropriation, because I won't have the ability to pay them the salaries that we would be offering in those hirings. So we're getting closer, but it's a frustrating process, and it's people are getting tangled up on some of the words rather than the intent of the rider, and it's I hate not being able to be nimble and to be able to say this is the common sense interpretation of the way that this goes. So
it's the AGs and what are they?
It's not the AG, it's the comptroller.
Oh,
The
controller.
staff of the comptroller.
The staff of the controller.
Yes. And the hang-up is that the focus on which revenue code the monies are deposited in. We have multiple revenue codes, and I think that the staff of the comptroller is not adjusting to the concept of TDLR where we have multiple revenue codes, because we are an umbrella structure and we have different programs that the money is put into these different revenue codes, but when you look at the total revenue that we generate, it's sufficient to cover the appropriations that we're given. And each year we go through the process of saying, are each one of the programs covering their own expenses? Do we make adjustments? And you're familiar with the adjustments that we're making, that in most cases we're able to lower the fees to the different license types because we're running greater and greater efficiencies.
Is this normal, the process that you're going through? Is this normally takes this time? Is it?
No. This is an anomaly. This is the first time we've run into this kind of roadblock or mental block on the part of the staff of the comptroller's office. So we've had meetings with the deputy comptroller and the chief revenue estimator and two of the other staffers that are involved in this. We've had letters going back and forth, and also letters are going back and forth between the fiscal management people over at the Department of State Health Services trying to get numbers. And it's
But
just,
this ride is authorized by the legislature. It's already been authorized. And
the transfer of the program's been authorized.
Yes, right.
With that bill passage, there was a rider that would set up the appropriations for us, and we've got the dollar amount of the appropriations, but what they're trying to say is that you have to show that you have enough money coming in, cash coming in, to cover the appropriation to pay for that transfer.
And the unfortunate part is that without having that revenue brought over to us, the only way to offset implementing that program is to raise revenue in other manners, which we don't want to do.
That's
because
correct.
it's not fair to the other license holders to have to be able to brunt the cost of that, plus then try and drop them back down again, because that's not a true cost of that particular program.
Right, and
So-
we've not even gone down that path with the staff of the comptroller's office because we have so many different revenue codes. Which revenue codes would we have to increase fees in order to satisfy their confusion? I choose my words well here.
Well, you did well there.
So it's
It's a frustrating standoff right
it's
now because of the fact
extremely
that we're trying to
frustrating,
get
and
it.
we know that the authors of the bill, the staffer for Price was concerned that the transfer is not happening right now. So Representative Price is alerted about it. The issue is how many other officials are going to come into this. I've had discussions with staffers at the Lieutenant Governor's office and with the Speaker's office about it, so they know about the issue. We just haven't stoked up the heat enough yet, but we're trying to work it out with the staff without having to do the stoking up too much heat.
Commissioner Shaw?
Yeah, does the Controller's Office not understand that these are some huge programs that TDLR is taking on? I mean, this is not something that you wait and see. I mean, you've got to gear up. You know, you've got to really start gearing up for accepting those programs. So I'm having a hard time understanding. I mean, are they asking you to do some fuzzy accounting?
No, well, I think that there was some inartful drafting on the rider. And part of that inartful drafting is that they were requiring that we show in the first year of the transfer that we would have enough revenue to cover the computer costs that we were going to incur in obtaining the computer system from Department of Health Services. Normally, when you have a computer purchase like that, that's a capital cost that's amortized over a 10-year period. You don't have to pay for it right up front. You have to show the amortization of it. That's not in that rider the way it's written. So that adds another $2 million, $3 million or whatever to the, they're saying that we have to raise right away. But we were able to show, and Brian wrote the letter to the comptroller's office saying that we can show that we have enough money coming in taking care of this. Part of the situation is that they're saying, no, money's going into state health services now, and they weren't counting that as money that we would be generating. And the point that we made in that discussion was all those dollars are green, they're all fungible, and all the money that's going into state health services for licensing right now goes into the state treasury. All the money we have for licensing goes into the treasury. The place to look for that pot of money is in all those revenue codes in the treasury, and not look at the revenue codes of each of the individual agencies and say, you've got to look at this shoebox only, where you've put this money in that shoebox, and if you haven't got enough money in that shoebox, you can't do anything that you're directing to. Brian, do you have some?
Yes, I will tell you that Bill has been pushing. The heat has not gone to the comptroller's office, but Tony and I have been scorched by Bill's heat on this, and appropriately so. This is an important issue, and I will tell you that Tony and Jerry have been in multiple daily conversations since the last commission meeting with the comptroller's office and the Department of State Health Services. This is the most important task that they have on their plate. They are, Tony and I talked at length yesterday. There's some encouraging movement on the part of the comptroller's office, some revelations that they are understanding that this is a bigger issue. There are several rabbit trails that have been created or developed that we're having to go down, and it's just the process. It's absolutely a process, and it's frustrating as whatever adjective you want to put on the end of that statement. But I will tell you that I would prefer that you know that we are working hard on this. but that we not continue to negotiate our position awkwardly in this meeting.
Well, and the programs that we've received in the past, this is a change of how we've had programs come over to us as far as from a funding
correct.
cycle.
That's correct.
Because previously, when we received the program, we received the funding for it.
September
Without-
1,
yeah.
it's done, and then all the challenges that come with bringing on day one.
And here we are, October 14th, and we still can't get this rectified. So we're hoping that maybe individuals that are either listening or sitting out in the audience right now would be able to turn around and maybe give a gentle little push to try to help us out here so we can get this program up and going and bring them over and get started where we need to be at.
There seems to be confusion on the target date. We have talked about, and that's why we call it a target date of March 1, 2016. Some people on the other side are saying, no, well, it's August 1st, 2016. Every delay in each day moves it in increments of weeks and months to where that will be achieved. There will be an August date if we don't get the money tomorrow, and it will be a September date if we don't get the money in a month. That delay in providing the money will assure that there'll be a delay in transferring the programs.
Just a moving target right now.
That's exactly right. The target is still March 1, but that's getting precarious. It's getting precarious, but Tony has been, he's really been pushing the envelope hard,
Okay.
Making some progress. And I think he had 2 conversations yesterday and 3 the day before and about 4 on Friday, going back and forth on this issue. And he's carrying our water well. He's really doing a great job on it.
Well, keep pushing, Tony.
Yes, sir. And I had 2 calls yesterday to the chief revenue estimator, and we're playing phone tag. But I'm talking up here, Tony's doing it down here, and Bill's pushing it on the other end. So we're going to be able to report something to you favorably.
So I'm doing the Khrushchev routine. Bang
All right. Any questions for
I
Bill
guess-
on this
I
item?
guess, yeah.
Thank you.
And I guess that's good, really. And I guess the other issue, if the controls staff is trying to do it, if there would, be any need for us to help try and meet with the controller to try and get something done, we may need to, consider doing that. Okay?
Yes, absolutely.
Okay, if you want to do that.
Will do.
And I'll be
Well,
happy
thank you
to
so much.
go with you and try.
And the good news is that the other program that was being transferred to us, the driver's education, came over to us on September the 1st. That's moving along swimmingly, and in fact, for the staff reports, Ray Pizarro is here to tell you where we are with that implementation. So
Okay, all right.
there is some good news on the
Okay. We'll hear that in just a second.
absorbing the
Yeah.
new programs.
All right, let's move on to item K, staff reports. Is that right?
That's your, no,
That's
well,
you.
your executive director first, Mr. Chairman.
Okay, let's do you first then.
We have outreach that's coming forward, and I don't know that I've got all of the outreach listed here because we have so many of the new programs that will be coming on once we get things straightened out with the appropriations issue. We're talking with the different groups for those programs from State Health Services, and it's all the meetings that we've had so far with those groups have been very good. But on October the 28th and 29th, we have a advisory board summit that we will be doing training for all of the new advisory board appointees. That issue will be coming up, the appointments will be coming up later in this agenda. October 30th, there's a PEO Leadership Council. That's the professional employment agencies or organizations. They generally have us come and do a contact with them when they have their meeting for their strategic planning. I'll be going to that on October the 30th. On November the 10th, we've got the career colleges will have their conference at the Woodlands. We're scheduled to go to that. Ray Pizarro, Brian, and I are on schedule to go to that particular conference. And then on November the 23rd, they have the Executive Women in Texas Government. I'll be one of the speakers at the breakout sessions. The topic will be expressing your vision to be successful, so that it's a project that I've been working on. It's a spinoff from the training that I got with the transformative leadership and also with the discussions that we've had with staff about vision and their core values. Then we have on March the 10th, we've got the Texas Speech Language Hearing Association meeting that will be going to that conference to talk to the individuals in that organization. That's one of the organizations coming to us from State Health Services. So that reaches out to March. That's a pretty
That's
long
way out
view
there.
of the different things that we've got on the horizon. With the staff development, I've got a project going right now that is what I call the core value business card project. And I've started that with meeting with the individuals from, or several of the individuals from the customer service division to talk to them individually. Met with them in a group, laid out what we wanted to do, and then have talked to them individually about which core value resonates the most for them. One of the things that they've been asked to do is when we get together for the initial meeting to come with some fact that is not in their resume, something unique about themselves. So one, that I can get to know them a little bit better, and also they can hear that from each other to get each other to know each other better. And then we start talking about the core values that we have as an agency and which one means the most to them, which one resonates with them. All of our core values are important to us. We try to live all of those core values each day, but for each of us there's going to be something that really has the special ring. Throughout my career, the core value of innovation has been something that's been special to me, and it's been part of the reasons why I've been successful in the different executive director positions. On my business card, the statement of that core value, without saying innovation and without just saying what the core value definition is that fostering creativity and change for a smaller, smarter government. And that's, as I told the individuals that have come to that, it took me about 2 weeks of looking at that, thinking about it, writing down a few things, and coming up with how do I distill that core value to get that message across that I want to put on my business card, so that when I give my business card, I'm giving an insight into what I'm about at this agency. The project's been great. The interaction with the employees has been wonderful. And what I wanted to do is just highlight 2 of them that we had with that. Maria Chinchilla is one of the customer service reps that's at our front desk. And the way that she defined her core value of customer service is, I think, really elegant. It's serving our customers with honor and dignity. And she really embodies that every day that she's sitting at that front desk, that she reaches out and really takes care of our customers. The other one I wanted to point out is Tuan Nguyen. His is innovation, and it's exceeding expectations by exploring and creating solutions. So we're having these discussions with staff that really focus on that core value, what our vision's going to be for the future. And I think that when we go back to those beginning elements for the agency, that's what makes the agency strong. And it helps us think about that, and that having that on our business cards will help us remind us of our own core values, so that daily that we're living that.
So is that when you put that on your business card, is that an advertisement, or is that is that a communication?
No,
is that a message?
It's a message.
It's a message.
In this case.
Thank you very much. That's it.
Are you
Thank
asking to
very much.
reconsider an item?
Thank you. No, thank you very much. Okay.
Brian, I'm going to pass to you. Wait, one other cleanup item that I've got. We received a letter that's Kay's distributed to all of y'all requesting that we have a advisory board meeting for the Licensed Breeder Advisory Committee. We haven't had a need for advisory meeting, particularly during the session that we're so busy with all of the legislative issues. But we have looked into that. We do have the meeting set for January 11th, would be the next date for the advisory board for the breeders. So that the request that we got that we have a meeting soon, that's the way that we've been able to fit that in.
This is Lynch, is that
And
right? What's it?
we will have a lot of advisory board meetings in the near future.
Yes, we will. Yes, we will, but after we take care of another agenda item. So we've not had a need to have a meeting, but, I'm sorry, what's the name here?
Let's see, what is it?
What's the name that's on here? Who's this from?
It was, what's her first name? Natalie.
Natalie?
Natalie?
She's a recent appointment to the advisory board.
Okay, so she's requesting a meeting, but we have not had a need for a meeting at this point in time.
That's correct.
So-
That's why we've had a long period without a meeting, because we had significant discussions when we adopted the initial rules.
Right,
and,
and which is to be expected, and I think
Yeah.
that's one of the things that, which is probably a good point to bring up, is that normally we look at 3 or 4 meetings a year, but only in the event that there's necessary rules to consider, anything needs to come before the advisory boards, and so we may go years sometimes without meetings from the advisory board simply because there's nothing to bring up before them. We don't want to use up their valuable time
Don't
to
want
be
to
able to
use
come in.
resources without
Exactly.
the
So, but as
output.
things come up, because I know that we've had some advisory boards that have not met in a while, did not meet for a period of time. I think Weather Model is probably one of them that did meet for a period of time.
Well, Boiler, I think, was
Boiler's
a
another
significant
one, yeah.
delay. And
So,
Commissioner Moses attended that meeting, and they made up for the lack of meetings over that time period.
They did.
By going all day long.
All day, that's right.
yeah. So I think that's one of the things that we do want to put out there to the advisory board is that as things come up, we will meet with you, but we don't schedule a meeting just to have a meeting.
That's right, just
Correct.
for the
So
process.
I think
Yeah.
just so our advisory board members know that. So, thank you.
Mr. Chairman, just continuing on executive's report, and I'll be very brief, I know we are short for time. You know, the discussion we've had earlier regarding the contingent revenue rider, that seems to be the cloud over the consolidation efforts, but it does not define the hard work that we've been doing. We've had some fantastic meetings with the Department of State Health Service employees and gaining a knowledge and an understanding of how those programs are going to operate. In the last week, our Assistant General Counsels had an opportunity to meet directly with, and it's something they've been desiring to do, to meet directly with the program specialists for the various programs, the 7 programs, to gain an intimate knowledge of how the rules are structured, what are some of the sacred cows in the rules, what are some areas that could probably be tweaked or improved. And so we had great discussions with that. Last week, George Bomar, myself, and Mary Winston went to San Antonio to a conference of the orthotists and prosthetists to see what's really a national conference of theirs, to see the products and literally the life-changing services that they provide to veterans and other folks who have had injuries that have required a prosthesis and those sort of things. Phenomenal opportunities to gain a knowledge of these programs. All of this has positioned us to, meet the March 1st, 2016 timeline. We're doing the work that's required, which is going through their rules line by line. When you finish your business today and make the appointments, we're going to have a meeting at the end of this month with the newly appointed folks to give them an orientation on what it is to be an advisory board member. And then we're going to start those advisory board meetings the second week of November and going into the third week of November to start reviewing the reformatting of their rules. That work is going to start so that in March, we are positioned to have the board adopt some rules that will flip-flop in exchange for their current rules, but they will look like TDR's rules and they will feel like TDR's rules, but they will embody and still maintain the standard of care that is appropriate for those respective industries. There's been a lot of communication. I could go on and on about George Bomar and simply how incredible he's been in managing the relationship that we've had with the Department of State Health Services staff. We are handshaking just like this. A perfect example is a recent addition, and I don't want to steal too much of Ray's report, but a recent addition to Ray's staff is a current member of the Department of State Health Services staff in their examination group. She is vital and critical to the continuation of those examinations that are going to go on until we take over the program in March. We've already set up the arrangement to make sure that we share that resource to ensure that there's no delay or that we don't hamper their ability to continue to do their job. That's how well this exchange is really working. So we're excited about it, and that's the story I really want to keep telling you, is that we're doing the things that need to be done to make sure that the transition is as smooth as possible and that we have success when this thing happens on the target date of March 1, 2016, which we're shooting for.
What's that date again?
March 1, 2016. I'm going to put that on my business card and advertise it as well as contact people on it. On that thing. Bill also asked me to give an update on the annual internal audit report. We received that 2 Fridays ago. Tony, also in his new role as our liaison for our staff internally. Obviously, Brad is the liaison to the internal auditor, and he is coordinating the responses from our respective division directors for the management response. We will be developing that language. We'll provide that obviously to the commissioners. We will meet with the financial work group prior to the next commission meeting, and then have that on the next commission meeting's agenda for discussion. But we are taking that process as serious and making sure that the things that have been identified to help us improve as an agency, that we take those things to heart and improve our agency. And I'm available to answer any questions if you have any.
Any questions for either Bill or Brian? Right.
Ray?
I think Ray is up. While Ray's on his way up, I do want to make note, of course, Commissioners, you did receive all the staff reports. One of the ones I do want to point out to you is, which I think is just a phenomenal landmark for this, Allie Faye Wright, down in Westlaco, 92-year-old cosmetologist, has held a license for 75 years with the state agency, and she was recognized. She was on our Facebook, put out on our website. I think it's just absolutely a telltale sign of her. I mean, 92-year-old cosmetologist with a license for 75 years. I think that's not only to be noted on our webpage and on our Facebook. I think she's got the most hits that we've ever had on our Facebook page. All the likes, comments, over 2,000 comments were made. I'm sure all congratulatory. But I have not had a chance to meet Allie Faye Wright, but I do wanted to kind of notate her and let everybody know. Congratulations, Ms. Wright. We appreciate the work that you've done for 75 years in the industry of cosmetology. So kudos to you.
Mr. Chairman, I'll tell you that in our society today, it's so easy to be cynical and so easy to type in that comment that is scathing and negative. It was beautiful to read all the comments that were said about her. They were so uplifting and so heartfelt. It just made you feel good. So if you're having that day or that moment, go find that post and you'll just be overwhelmed with how positive people can be in recognizing an accomplishment that Ms. Wright had. It was great.
Oh.
Ray,
Ray, go ahead.
Good morning, Mr. Chairman, members of the board. My name is Ray Pizarro, Director for the Education Examination Division. First, I want to congratulate my staff. I'm just amazed on how well they have embraced all of the changes. Our division, as you know, has gone through drastic changes since a year ago, from leadership to different sections being added and different people and programs, and the motivation from the staff and the hunger for the challenge. You can see the passion with each and every one, and I'm just really happy that I'm in the position to lead those folks. The first thing I want to talk to you about is with just to explain more about what's happening with our division. We have now a section that's called Education and School Services section, and that's led by Kim Witt. There are lots of different changes going on there. We are now currently seeking and trying to recover a lot of the CE record completion fees. As you know, that has been a challenge, and we have finally acquired QuickBooks, and Lorraine Shroof, who works for in Kim's team, she has done an amazing job of setting that up, getting the statements and the invoices out, and recovering those fees from those course providers. As Brian mentioned earlier, within that team, we've hired Miss Alice Bradford from DSHS. She is just a wealth of expertise that she's going to bring to TDLR and to the team. She has curriculum review expertise from continuing education and the examination requirements that all will impact our agency from those programs that are moving over to TDLR. We also have a section called the School Inspection and Site Visit section, which is led by Marco Rodriguez. Marco leads a team of 4 inspectors for right now. Hopefully that's going to increase. And what we're currently doing is we are looking at the barber and cosmetology schools, and that would encompass now the driver safety and driver education schools, and of course all of the schools that will be transferring over from DSHS to TDLR. So basically we're going out and inspecting those school providers, those education providers. In addition to that, we'll be doing site visits, which would be the site visits that's going to be different from the actual inspections is more like trying to seek out best practices, trying to educate the providers on the good things they should be doing instead of waiting for the inspector to come over and give them a hammer saying, here, you've done wrong. This is the wrong thing to do. So we're doing that, reaching out and giving those schools that benefit of the doubt that let's do the right thing. The big thing that we are doing right now, and I want to say thank you to Tony Cuvion. Not a lot of we haven't said this enough for Tony. He's been the lead on implementing the driver education, driver safety team, and I'm there with him to try to get this thing done, and he's done a tremendous job. Within our division, we've created a new section called the Driver Education and Safety section, which is led by Carrie Hodges. Carrie comes to us from the Department of Public Safety, DPS. As you know, the driver education, driver safety came to us in 2 components. Part of it came from DPS, the parent taught, and the other part came from Region 13, which was part of, if you will, TEA, an extension of TEA. We've gained employees from DPS, and we've also gained employees from Region 13. We have been working very closely with these individuals as being part of the TDR family. They have stepped up and have enlightened us in many different ways on things we need to improve, things that we need to change. And so you're going to be seeing a lot of recommendations on rule changes with driver education, driver safety to improve the process and to improve how we deliver that for the industry here at TDLR. The parent taught is going very well. That's one of the big steps we've done that DPS was not able to do, or just did not have time to do, let me just say it that way. We have now have the parent taught packet that the parents can purchase. They've always had to mail that money in to DPS. When we first acquired it, they were mailing monies into us to obtain that packet. But since in the last couple of weeks, we have made that available online. So that is a huge change. The course providers are very happy about that, saying, wow, this is great. Now they just could purchase it online. It makes the process a little bit quicker. You're going to be seeing a lot of these things that we're going to be changing. We're currently working with the current system that we call DES system on all of the licensees of the providers are in this system that was transferred over from Region 13. So we're studying it, learning it. We are currently issuing out certifications. We're issuing out the DE 964, which is the actual the little certificates that the students would get, and those who get a traffic tickets, the little completion certificate. That's the DE 964. You all know what I'm talking about.
No, not really.
No, you better tell us.
And we failed to say that we do.
So we're working with those different things. We're trying to make make the program a big success, and I think we're heading the right way. That's all I have for you right now. If you have any questions for me, I'll be happy to answer them.
Any questions for Ray? Appreciate your work.
Thanks.
There's a lot of work ahead of, a lot of work that was accomplished, a lot of work still ahead of you.
Yeah, plenty.
Thanks,
Thank you.
appreciate it.
Thanks very much.
Let's move on to, that includes staff reports. L, advisory board reports. Susan coming up.
Good morning. I'm Susan Stanford with the Office of Strategic Communications. Chairman Ayers-Mendez, first off, I'd like to thank you for recognizing Mrs. Wright. If she were here, she would have stopped you mid-sentence, though. She's 94 years
my
old.
apologies.
And I'm not sure at what point every year counts.
She did not look,
but-
she was 94.
No.
So you're saying she looked 92?
Go ahead, Susan.
She stopped, she stopped Senator Lucio in the middle of the city commission meeting and corrected him because he also thought she was younger than 94. So, thank you. For the advisory board, the Office of the General Counsel has continued to update the training for open meetings at every meeting that we've held. Also, we're continuing to do the rule changes, the amendments, and that's basically all that I have that's been going on. We do have many meetings between your meetings, and so we'll be making reports regularly to you. All right, is there any questions I could help you with?
Any questions for Susan? Thank you very much.
Thank you.
Appreciate it. Commissioners, real quickly, let's move on to item N, any public comments. At this point in time, if anybody wishes to have any comments, we will give you 3 minutes in which to be able to speak to the commission about anything. We ask that you state your name. So at this point in time, any public comments can come forward.
Ooh, the suspense is killing me. The advisory boards.
There being none, just kind of FYI, we have a meeting scheduled for November the 18th, January the 6th, February the 10th, which is the ones that we had talked about in our previous meeting. Because of some other rule adoptions that we have to do, we're looking at a meeting on Wednesday, March the 9th, to be the next one after that. So our next meeting, November 18th, January 6th, February 10th, and now we will add March the 9th. So I'm sure that the staff plans them that way ahead, so I just want to let them know. Let's go back up to item M. I saved this for last. I know that there's been a lot of discussion on this, a lot of communication going back and forth. With the recent legislative change, the Texas Department of Licensing Regulation received some additional programs, and I think it's a testament to not only what Bill and Brian do with the agency, but also what staff does. They have shown to the legislature that we are the umbrella agency, that we are the agency that is efficient, that we, for lack of a better statement, we take care of our business.
Yes, and Mr. Chairman, while you're talking about the staff, if I could interject the recognition for staff that really put together the applications for the appointments and got together with you to get that information. Delia Luna, Delia's here.
Yes, she's here.
Oh, he has? Okay.
That's fine.
I understand you have the name, so I'll let you do that. I'm
No,
sorry.
you already popped the bubble. You might as well keep going. But it is. It's Delia Luna who's in the back. She's back there in the back. We had Tamala Fletcher.
She's not here. She's at the office.
She's at the office. They've got her working. Jeff Kopus, Mary Winston. I've also got William Ware, Teresa Alvarez, and Mike Fickle.
Correct.
And of course, our Deputy Director, Brian Francis, was leading the team. Let me tell you that this group, and also I think the bill implementation team had some say-so because they have to implement these changes. Let me tell you that this was a daunting task when you begin to start talking about the programs that we're getting over to us now, plus the fact that we are going to be taking on these new programs. and now the applications that came in. I want to thank the individuals that I just mentioned. They did an extraordinary amount of work. I came in several times to meet with staff, and every time I walked in, they had everything waiting for me. So I need you to talk to my wife about supper sometimes. No, I'm just kidding. That's, yeah. Can we edit that out? Are we on a delay here? But they did a fantastic job of getting all the information in place. They had the applications printed out. They had already vetted them. They had gone to the different state agencies, the Department of State Health Services. They had been over to DISHES, which I'm saying out there, and began to start communicating with them about others, individuals that were involved with those particular programs. And so I tell you what, they did a yeoman's work. They hustled. They got it all lined out, and they made my job easy. I simply had to come in and begin to start looking at the process, and we talked about them. You know, there was a lot of discussion taking place on the applications because we wanted to make sure that we had a board, advisory boards, that we felt was representative of the entire state of Texas, from the different demographics, the different diversity, and wanted to make sure that we had everyone represented. I can tell you that the appointments that you have before you, there are still some open positions. We have some public member positions that we're still seeking. We've reached out to some different organizations and agencies throughout the state of Texas and hope that they would be able to provide to us some additional names of public members. And if you're listening and interested in a public member, we would invite you to go out to our website and submit an application as a public member on some of these advisory boards if you're interested in being involved. You know, I talked with a lot of them. I primarily visited with those individuals that I felt would be a great candidate as a presiding officer, and talked with them extensively and kind of asked some questions there. But now I come before
Is
you.
there you know, maybe we could make available to us if there are, you know, still vacancies and they're looking for public members?
There are.
Maybe they could.
They're out on our website. If they go out to the website, they'll be able to find all of those that were still out there.
Is it possible it could be
Yes, sir.
provided us a
Sure.
list?
We'll give you
us?
by,
Yes.
yeah, we'll give you
Good.
by
Good.
board which public member
Yeah.
seats are available. Some of them have some unique characteristics requiring a doctor, you know, medical degree in a specific area. So we'll make sure that you'll know by board which public members and the unique requirements for each of those.
That would be good.
Absolutely.
And I'm
We'll
sure,
get that
I'm
started.
sure, yeah, I'm sure Tamla's listening right
Because,
now, and she started working on
I
it.
should do that, yeah.
And Delia's back there, so she'll know what to go
Delia's
back and ask.
taking mental notes there.
But there was a team that was put together, and again, we'll make sure that we get that to, because I can tell you that any help that I can receive for appointments would be greatly appreciated, because there are a lot of vacancies.
Yeah, and then also make sure that,
And a lot
you
of
know,
appointments
a
today.
lot of appointments. I think that, you know, we really need to, you know, with some of these locations, make sure that our North Texas continues is represented on these boards. I don't.
Well, I definitely took that in consideration.
Okay, thank you. I hope you would.
But and you're
We do.
right, because of the fact
That's
that
right.
there is a
That's right.
representative demographics that we
Yeah.
want to make sure,
Oh,
from
yeah.
a
That's
geographical
right.
remit, to make sure that we're representing the entire state of Texas.
That's right.
I can tell you that some of these were so specific.
Yeah. I know it
that
makes Texas.
it
Makes
made
tough.
it very difficult. Yeah,
Well,
it
it
made
really
it
is.
tough, it
Okay.
made it very difficult.
Okay.
But again, staff did a fantastic job, so my
Good.
hat's off to you. Thank you very
Good.
much for the work that you performed
Good.
and the work that you did.
So did I hear Commissioner Moses say that everybody should be from North Dallas?
I didn't say that.
I
said we
didn't
should-
take it that way.
I said we should be represented because we have, you know.
I do have a question.
Yes.
We do.
Did
We
some
do.
of the members on the advisory boards come from the previous agency?
Absolutely.
Yeah,
There's
there
a
are
really good portion.
And I'm glad you mentioned that. There are some carryover from previous boards that we brought over as on the advisory boards. That is, some of those we do see, and you'll see that in some of the advisory boards. So, with what I'd like to do is go ahead and get started. You have before you a relatively large packet, which includes the applications of the individuals that I'm recommending, but you have a memo before you now. Actually, what I'd like to do is we'll take each one of these individually, because we do have so many that I want to be able to put this out for so I would look for a motion on each one of these boards The Athletic Trainers Advisory Board, I am appointing or recommending to appoint David Weir from College Station as the presiding officer with his term to expire in January of 2019. Daryl Gaines from Kilgore, Texas, to expire January 2021. Dr. David Schmidt from San Antonio to expire January 2017. Brittany Webb from Martindale to expire January 2021.
Make a motion to approve
Second.
appointees.
Second.
We have a motion, a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. The Dietitians Advisory Board, I'm recommending Janet Suzanne Hall from Georgetown as to be the presiding officer to term to expire September 2021. Irma Gutierrez from Georgetown, her term to expire in September 2017. Matilda Ladnier from Sugar Land, Texas, to expire September 2017. Ida Moreno Brown from El Paso to expire September 2019. Leanne Skinner from Austin, Texas, to expire September 2019. Mary Kate Weems from Waco to expire on September of 2021.
Are these, I guess, I got another question. I guess, are these new appointments, or these people have they already been serving? I don't know.
In this
Mr. Chairman,
particular board, I'm not
Huh?
sure. We'd have to go back
There's a
and
good
look.
mix of current
Yeah.
board members.
Okay.
That are coming from, and remember, they're coming from a
Yeah,
policy
right.
board.
Sure.
An advisory board. And then there are also some folks that were on previous boards, but there are some new faces.
Okay.
And new energy in this group as well.
Good.
So it's a combination of current board members, and
And
there's
new
one
ones.
person that was a previous board member, and I don't want to misspeak there, and there's some new blood as well.
Good.
And if you're interested in finding out the specifics on that, I'm sure that we can get Tamala or Delia to be able to email that to us. But there's a mixture
Good.
throughout all these. And
Good.
I can tell you, after a while, it's kind of like looking at numbers. All these
I
names
tell you it
begin to
is.
start
I
flowing
tell you, when
together
you get
after a
all
while.
these names.
This
So-
one was really interesting because if you see the categories, community management, clinical, consultant, and educational, those are recommended
That's right.
categories. Well, you had folks that some of them had all six, and so they could be
They could serve
any
either one of
position.
those
And then it was an open
capacities.
one, so trying to match that up. And then there were some people that only had two of them, so you had that little matrix or problem challenge.
So move as recommended for this board.
Yes, sir.
That the members be
We have a
approved.
motion, a second. All in favor signify by saying aye. Those opposed, motion carries. For the Driver Training and Traffic Safety Advisory Committee, I'm recommending Ricardo Benavides from La Feria, Texas, to be the presiding officer, term to expire November of 2021. David Bruce from Houston, Texas, term to expire November of 2019. Blake Garrett from Austin, Texas, term to expire November 2017. Cindy Jo Garrett from Plains, Texas, to expire November 2017. Frances Gomez from Austin, Texas. She is an appointment by the Department of Public Safety, which is a part of the statute. Kevin Knapp from Amarillo, Texas, term to expire November 2019. Patricia J. Lark, College Station, to expire November 2021. Carlos Reyna from San Antonio to expire November 2017. Nina Jo Saint from Houston, Texas, to expire November of 2019. And Glenn P. Winningham from Sugar Land, Texas, to expire November of 2021.
So move to accept.
We have a motion
Second.
and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. For the Hearing Instrument Fitters and Dispensers Advisory Board, I'm recommending that Benjamin W. Norris from Elmont, Texas, be the presiding officer to expire February 2021. Jackie Cooper, Spring, Texas, to expire February 2017. Richard Davila II from Lubbock, Texas, to expire February 2019. Gary Hahn from San Angelo, Texas, to expire February 2017. Jesus Rangel from Longview, Texas, to expire February 2021. Mary Tross from Seguin, Texas, to expire February 2019. I'm sorry, Amy Tross, Amy Tross from Seguin, Texas.
So move to accept.
We have a motion
Second.
and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. For the Midwives Advisory Board, I'm recommending that Meredith Rentz Cook from Keller, Texas, be the presiding officer to expire January 2021. Brenda Buffington from Livingston, Texas, to expire on January 2017. Janet Dermeyer from Comfort, Texas, to expire January 2019. Laurie Frimgen from Austin, Texas, to expire January 2019. Dr. Charlotta Gilroy from Houston, Texas, to expire January 2017. Linda Hart from Texas City, to expire in January 2017. Victoria Minhart from Austin, Texas, to expire January 2021. Helen Nelson from Grand Prairie, to expire January 2019. Dr. Michael Nix from Austin, Texas, to expire January 2021.
So move to accept.
Second.
We have a motion, a second. All in favor signify by saying aye.
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 Those opposed, motion carries. The orthocist and prosthetist, I think I got that right.
You did pretty good.
That's pretty close.
Impressive.
Advisory board. This particular advisory board is a little different. The statute states that the board would elect their own presiding officer. So I simply have to assemble them together, and then I guess they'll Indian wrestle, figure out who's going to take over the meeting in the beginning. I'm not sure how that's going to work, but anyway.
We're going to see who has the best looking business cards.
Yeah.
Yeah, that's right, yeah, that's right.
But for the advisory board,
Okay.
I am recommending Kevin Matthews from Converse, Texas, term to expire February 2019. Miguel Mojica from Coppell, Texas, to expire February 2017. Sterling Phillips from Lubbock, Texas, to expire February 2021. Randall Duncan from McKinney, Texas, to expire in February 2017. And Catherine Mize from Double Oak, Texas, to expire February of 2021.
So move to accept.
Second.
We have a motion, a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. For the speech language pathologist and audiologist advisory board, I am recommending Sherry Sansabrian from Lubbock, Texas, to be the presiding officer, term to expire September of 2021. Emmanuel Bodner from Houston, Texas, term to expire September 2021. Patricia Brannon from San Antonio, Texas, term to expire in September 2017. Chevelle Bryant from Sugar Land, Texas, term to expire September 2019. Dr. Tammy Camp from Shallowater, Texas, term to expire September 2017. Catherine Hinian, is that right?
That's correct.
Hinian, to expire September of 2021. Robert Novak from San Antonio, Texas, to expire September 2017. And Kristen Plummer from Round Rock, Texas, to expire September of 2019.
So moved, Mr. Chair.
We have a motion.
Second.
Second. All in favor signify by saying aye.
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 Those opposed, motion carries. Commissioners, these next ones that we have are simply reappointments or appointments. The ones that I've just given you were the new programs that were come over to us. And I know that there's, I think that our bandwidth is probably full right now with people listening. Congratulations to those that were appointed, and to those that did not. Let me tell you, it was a tough decision because we had so many applications come in. I'll give you an example. I believe it was the driver's ed. We had over 150 applications, and we only had 11 spots. So it was a difficult process to go through, but I believe that we have advisory boards for these new programs that are representative of the industry, representative of the state, and we believe that they'll do a great job. And so, again, congratulations, but of course, as you know, and we encourage everyone that was not selected to be on an advisory board, we invite you to participate. We have meetings that will be published out. As was mentioned earlier, these meetings will begin probably the second week of November, and I think I'm going to be living in Austin for about a week and a half or so, trying to get to all these meetings. But we look forward to working with the new programs and the new boards, and we're going to try and make it as painless as possible. So,
Mr. Chair, just to prolong the meeting, maybe about 42 more seconds. Would it be possible to go on and read the names of those last two boards? There are folks here in the audience that probably are here for those appointments
yeah,
as well.
I was going to do that.
Oh, I didn't.
Thank you.
Yeah.
But
Let's look this
on
way.
the recommendation of our Deputy Executive Director, I'll go ahead and read these names. The Electrical Safety and Licensing Advisory, appoint John Lewis from Buda, Texas. His term will expire in February 2021, and reappoint Keith Bell as the presiding officer from Forney, Texas. His term will expire in February 2021. And reappoint Christian Wagner from Austin, Texas. His term to expire in February 2021.
So move as recommended for the electrical board.
We have a motion
Second.
and a second. All in favor signify by saying aye. Those opposed, motion carries. For the Towing Storage and Booting Advisory Board, appoint Jane Spears from San Antonio, Texas. His term to expire February 2021.
So move as recommended.
We have a motion and a second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Commissioners, you also received a packet of all the applications, and before each application, the staff did a great job of giving you the statute and the requirement for each individual board and what was required of them. Just kind of so you'll know, there is still some openings, as I mentioned earlier, on some of these boards, so we will look for public members to be coming through. Again, I'd encourage you to go through and take a look, because you may see some openings that are out there that you know of someone, and we would definitely request that you go ahead and have them apply, and then follow up with a email or a phone call to me would be great. That way I'll know, and I'll take your recommendation, and we'll move forward from there. So. But again, congratulations to those that were appointed. We look forward to you being productive as a part of the TDLR family. Again, my staff for that did all the work. Thank you so much. You did so much for me. And Brian, I appreciate you heading that up and pushing them to get that out and get it done. So thank you very much.
Thank you.
I think, Kay, we've taken care of everything. There being nothing further, it's about 11 o'clock. This meeting's adjourned.
Very good.